Okay, so we're diving into, well, this is a bit of a head scratcher this time.
Oh, yeah.
Yeah, it's how the Indian Insolvency and Bankruptcy Code, or talking IBC here, how does it deal with these claims, but specifically the ones that are like past their due date, time barred, all that.
Right, right.
And you've given us so much legal analysis, actual pieces of the law, summaries of court cases.
Yeah, well, it's a dense area.
It is, like you said, navigating tax claims in the IBC. It's a maze. So let's see if we can find our way through.
I like that. A maze is a good analogy because the IBC itself is still relatively new. We're talking what came into effect in 2016.
Yeah.
So lots of room for interpretation. The courts are going back and forth. It's definitely a process.
Which, let's be honest, is where it gets juicy for someone like you, right? Like, you want to know not just what the law says on paper, but how it's actually playing out.
Absolutely. The real-world application of it all.
Exactly. Now, I know you know the basics, but for our listeners who might be new to this, let's just do a super quick recap of the key players here.
Sounds good.
So we've got our creditors.
Right, the ones who are owed money.
Exactly. And they're making what's the term?
A claim.
A claim, right? Like, hey, this company owes me this.
Exactly. Could be a direct payment. Could be some kind of remedy for, maybe a contract that went wrong.
Right, like a broken agreement, something like that. Okay, so
Yeah.
that's a claim. Now, when that claim, it's like definitely due. It's not, well, maybe not. We're talking,
It becomes a debt at that point.
Yeah.
Debt. There we go. And of course, if they don't pay that debt on time, my friend, we've got ourselves
a default.
Default.
Dreaded default.
Exactly. Now, here's where I felt myself getting a little turnaround. Because India has the Limitation Act, right?
Yes.
And that's basically saying, hold on, you've got a certain amount of time to actually take legal action on this claim.
Right, you can't just wait forever.
Exactly.
Yeah.
The problem is, and maybe I'm wrong here, but the IBC, it doesn't come right out and say, if this time limit, it applies to that whole claim verification process, right? With the IRP, the resolution professional.
We're spot on. That's the ambiguity, that lack of explicit clarity right there. That's what makes this whole area so tricky. Because on one hand, you've got this law saying you've got this much time.
Yeah.
But then the IBC, when it comes to this specific process, it doesn't.
Doesn't mention it. Doesn't mention it.
So then you're in this gray area, and that's what I love about what you've dug up, is it's like, okay, so if a creditor couldn't even start insolvency proceedings on their own because let's say their claim is way past the deadline.
Time barred, as they say.
Time barred.
Yeah.
Can they still kind of benefit from the process once it's begun by someone else?
Exactly. Can they sneak in through the back door once the party's started?
That's a great way to put it.
And your sources, they really get into both sides of this. I mean, some experts are like, absolutely not. That totally defeats the purpose of the Limitation Act.
Right. Like, what's the point of having this deadline if
you can just circumvent it through the insolvency process, it undermines the whole thing, not to mention the burden it puts on the resolution itself. Imagine you're trying to create this viable plan, save this company, and suddenly you're on the hook for debts from, like, forever ago.
Oh, total chaos.
Chaos. One of the legal analyses you gave, you used a great example. They said, allowing these time-barred claims in IBC, it's like saying, okay, you can't sue someone for a debt that's 20 years old. But if they happen to declare bankruptcy, come on down, you're first in line.
Doesn't make any sense.
No, it really doesn't. It incentivizes people to just sit on these claims and wait for insolvency rather than, actually trying to work things out beforehand.
Right, like actually address the financial issue when it happens.
It's a recipe for a very unhealthy economic environment.
For sure. But here's where my brain starts to spin a little. Just because the IBC doesn't say anything about the Limitation Act, does that automatically mean it's irrelevant?
Ah, you see, that's where the interpretation gets fun. This is where we dive into the legal weeds a bit.
Yeah, the waiters.
Because one of your sources pointed out something really important. The IBC, when it defines what a claim is, it's very specific. A claim, under the IBC, means you have an existing right to payment.
Right, okay.
But think about it. If your claim is time-barred, you've legally lost that right to payment.
That's a claim in name only.
Exactly. Like, I could claim I deserve $1 billion. That doesn't make it true.
Right. It's like me saying I have a claim to the English throne because, way back when. Anyway.
Exactly. So it's this claim-admitted loophole, as your source called it.
Yeah.
The IRP, the RP, they might list it, but if it doesn't have that fundamental legal basis, it's questionable.
Interesting. So even if they say, yep, this is a claim, the court might be like, hold on.
Potentially.
Yeah.
Now, having said all that, Recent rulings from the NCLAT, that's the National Company Law Appellate Tribunal, they've muddied the waters a bit.
Oh, no, really? More to think about.
Just a little.
Yeah.
The State Bank of India versus ARGL Limited case, this one really jumped out from your research.
Oh, yeah, that was a wild one.
Even though the creditor didn't formally file a claim, the NCLAT said, nope, it's in the company's own records, we have to consider it.
It's like the court was saying, guys, we're trying to get the real picture here, not just play gotcha with the paperwork.
Exactly. And this case, along with a few others, it points to a much more active role for the IRP, the RP. They can't just be a rubber stamp. They've got to investigate, look at the company's records, really use their judgment.
So it's not just, did you submit this form on time? It's more like, what's the real story here?
Exactly.
Yep.
And to make it even more interesting, the RPS infrastructure case. This one showed how resolution plans, they might need to factor in future claims.
Yeah.
You know, those what-if scenarios, contingent liabilities, things like that.
Oh, man, that's a lot of balls to keep in the air.
It is. It's about trying to anticipate potential issues, which, let's be honest, isn't always easy.
Not at all. So we've got this thing with time-barred claims. We've got courts trying to figure out the rules of the game. And, oh boy, because it wasn't complicated enough, let's add tax claims into the mix.
Ah, yes. Because tax claims under the IBC, now those are a whole other beast. Your research on that really painted a picture, I'll say that.
It's like trying to herd cats while riding a unicycle. Just when you think you've got it, something else pops up.
It's true. Tax claims, oh boy, they really add a whole new dimension to this whole IBC landscape, don't they?
It's like we were in a maze before, but now we're in a maze and there are like trapdoors.
And moving walls, maybe.
Right. Like it's not just one company and its creditors anymore. Now you're bringing in the tax authorities with, you know, their own set of rules.
And priorities. Let's not forget their priorities. It's like trying to merge two completely different highways, but it's rush hour on both.
Oh, stop. I'm getting a headache just thinking about it. And those court cases you sent, I mean, the Rainbow Papers case, the Pashmanchal case, all of those really show that, like, back and forth happening.
You know, they do. It highlights the tension.
Yeah.
Because at the core of it is this very fundamental question. Are tax authorities automatically secured creditors under the IBC just because the tax law says so?
Right.
Or does the IBC's own pecking order, that waterfall payment system,
The one that determines who gets paid first if the company goes under, right?
exactly, does that override those pre-existing tax rules?
So it's like two kingdoms battling it out. We've got the tax authorities saying, nope, we get ours no matter what. And the IBC is like, hold on, we've got a system here. Secured creditors are first in line.
It's a good analogy. And this isn't just some theoretical debate either. You know?
Oh, no, not at all.
This has huge implications for how these insolvency proceedings actually play out.
It's the difference between tax authorities getting paid in full and potentially leaving other creditors with nothing or having to wait their turn like everyone else.
Exactly. It completely changes the game.
Hugely. And you highlighted that one case, Principal Commissioner of Income Tax versus IMS Assam Company.
Right, an NCLAT case.
Yes, and they ruled that tax dues, they're considered secured debts. But then you've got the Bombay High Court in that NRC Limited case.
Right, seemingly going the other way.
It's enough to make your head spin. It seems like nobody really knows what's going on.
Well, that's a bit dramatic.
Yeah.
But it does show the uncertainty that still exists. Until the Supreme Court steps in and gives us some definitive rulings, we're going to keep seeing these conflicting interpretations, these gray areas.
It's kind of exciting though, right? In a weird way.
Well, exciting might not be the word I'd use, but it definitely keeps things interesting.
True enough. Okay, so we've got this whole time-barred claim issue. We've got courts trying to figure out if these laws even make sense together. We've got tax authorities doing their own thing. It's a lot. And it makes you wonder, where does that leave the whole point of the IBC?
Which, if we remember, is to give companies a real chance to start fresh.
The clean slate, right, to restructure, get back on their feet, all of that.
Precisely. And this is where that SR Steele case becomes so important. The Supreme Court, they really emphasize that the IBC, it's about this clean slate for companies to help them contribute to the economy again.
Which, I mean, it makes sense. It's hard to start over when you're dragging along every debt you've ever had since, like, forever.
Exactly. But here's the catch. That whole clean slate idea, it relies on everyone having their act together from the beginning.
Which, come on, this is the real world we're talking about.
Right. Deadlines get missed, paperwork gets lost.
Things happen.
Exactly. So that clean slate can get a little muddled. And that's the heart of the dilemma. The IBC, it wants to be efficient, it wants to be fair, it wants to bring some finality to this corporate restructuring world.
Makes sense.
But in reality, it's still trying to figure out how to balance that need for finality with the need to address legitimate claims, even if they pop up a little later than expected.
Right. It's like you're trying to solve a jigsaw puzzle, but the pieces keep changing shape on you.
That's a great way to put it.
And this is where I thought your research got super interesting, because one of the sources you sent, they proposed a very bold solution.
Oh, which one are you thinking of?
The one about amending the IBC so that a company's own books of accounts,
Yes.
they become the ultimate source of truth when it comes to these claims. Like, not just what creditors formally submit, but what's actually in the company's records.
It's an interesting proposition. On the one hand, you're going straight to the source. No more relying on potentially incomplete information, right?
Exactly. You'd think it would make things much harder to, like, hide things or for debts to slip through the cracks.
Theoretically, yes.
Yeah.
But as with any major change, there are always potential downsides.
Oh, for sure. I mean, imagine you're a smaller company. Do you have the resources for that kind of meticulous accounting?
It's a valid concern.
Mm-hmm.
Could actually make the process more burdensome, especially for those who might not have teams of accountants at their disposal.
Exactly. And then there's the question of, well, what if those books aren't accurate?
Ah, yes. The issue of human error, or even intentional manipulation.
Right. You'd be basing these huge decisions on potentially flawed information, which kind of defeats the purpose.
It does make you think there are always going to be these trade-offs, these complexities, no matter which way you approach it.
Which, I have to say, is what makes this whole deep dive so fascinating. It really does. Like you said, it's not just about knowing the rules. It's about, I don't know, understanding how they actually work or don't work in the real world.
Exactly. It's messy, it's complex, and that's what your research does such a good job of highlighting.
I thought so too. Like, it wasn't just laying out the problems, it was really making me think about, okay, but what are the potential solutions? And even then, could those solutions create other problems?
It's that law of unintended consequences rearing its head again. Because you try to fix one thing, and it might have a ripple effect somewhere else.
For sure. And I think that's what's so valuable for our listeners, right? It's one thing to know how the IBC works on paper. It's another thing entirely to see how these cases, these real-world situations, how they're shaping the law.
Absolutely. It's an evolving landscape, and you have to be aware of those changes, those nuances, to really navigate it effectively.
So for everyone listening who's now knee-deep in this world of time-barred claims, court interpretations, tax authorities throwing their weight around, what would you say is, like, the big takeaway here?
I think the big takeaway is to stay curious. Keep asking those questions. Keep digging deeper, because there are always going to be these gray areas to contend with.
Always more to learn.
Always more to learn. And maybe, just maybe, as you learn more about these complexities, you'll come up with some solutions of your own.
Ooh, I like that. So it's not just about understanding the problems, it's about being part of the solution, right?
Exactly.
Finding that balance.
Because ultimately, the IBC, it's not just about legal technicalities. It's about finding that sweet spot where companies get a genuine shot at a fresh start, but we're also making sure everyone's being treated fairly.
Absolutely. Striking that balance, as always.
Yeah.
Well said. And on that note, I think we'll wrap up this deep dive. As always, thank you so much for bringing us such thought-provoking material.
My pleasure. It's always a great discussion.
And for our listeners, thank you for joining us on this journey through the fascinating and sometimes frustrating world of the IBC. Until next time.